The Honorable presiding judge and judges of the North Carolina Court of Appeals. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Horn. Good morning. My name is Chris Dillon. Welcome to the North Carolina Court of Appeals. I'll be presiding today. Also presiding will be Judge John Arrowood and Judge Reuben Young. Dan Horn, our clerk of the Court of Appeals, will be keeping time. We have one case on the calendar, and the case is State versus Gray. Mr. Horn will be keeping your time, so please let him know if I'll allow Ms. Katz, if you're ready to proceed, just let Mr. Horn know how much time you'd like to reserve. Are you ready to proceed?
Yes, Your Honor.
Okay, well, you may begin.
May it please the court. My name is Jillian Katz with the Appellate Defender's Office. I represent the defendant, Antonio Gray. I'd like to reserve 5 minutes for rebuttal.
Okay.
When he was arrested, Mr. Gray couldn't stand up or walk on his own. He was unresponsive to questions. He fell asleep in the patrol car, and he laid his head down on the interview table while he scrawled a partially illegible statement. It is clear under these facts that Mr. Gray was not conscious of the meaning of his words. The trial court used the wrong test, but even under the correct test, Mr. Gray's statement was not voluntary. Furthermore, the trial court disregarded the request for the Allen charge in response to a jury note and instead told a holdout juror to be satisfied with the circumstantial evidence that Mr. Gray was the driver of the car. Mr. Gray was prejudiced by both of these errors, as the only issue in his case was whether he was the driver of the car. For this reason, he's entitled to a new trial. I'd like to start with issue 1 regarding the voluntariness of Mr. Gray's statement. At the accident scene, Mr. Gray was described as being intoxicated by 2 witnesses. Trooper DeMuth testified that he couldn't stand up on his own, and he was using the car to prop himself up. He didn't respond to questions from EMS whether he needed medical attention.
Is it true that he actually wrote this statement out himself?
Your Honor, there is no video of his interview, but testimony indicates that he did in his own hand write the statement.
In his own hand date it to a date that no one had given him, is that correct?
I'm sorry, can you repeat that?
He dated the statement, and that's his handwriting dating the statement, and in the testimony that no one told him what the date was?
Yes, Your Honor. The testimony indicates that he wrote it in his own hand and that he did date the statement. But if you look at the statement, which I included in my brief, the statement speaks for itself. It's very difficult to read, and it doesn't make a lot of sense. The content of the statement is sort of incoherent, grammatically incorrect, and it's very oddly phrased.
Well, how much are we bound by whatever findings the trial court made regarding, his whether or not he was with it or not with it? I mean, what findings did the trial court made? We're bound by those if there's some evidence to support that.
The court here didn't make a lot of findings.
I guess my question is, was the findings not enough that the trial court made, and why?
Well, so the court here did not make a lot of findings. It mostly just recited the testimony. But the court here did not make any findings about whether he was unconscious of the meaning of his words. Rather, the court made a finding that he was not unconscious and that he was not in a mania at the time. And this is not the correct test. Both the court and the prosecutor seem to believe that actual unconsciousness was part of the test for whether a statement was voluntary. But the test is actually whether he was unconscious of the meaning of his words. And there's no findings about that. So
did the trial court make findings, or did the trial court merely recite testimony? Did the trial court say this is what happened, or did the trial court merely say so-and-so testified this is what happened?
The trial court mostly just recounted testimony. The trial judge did make a few findings. Like I said, the one about he was not unconscious and he was not subject to fits of mania. And also a finding that he was able to understand his rights and able to write the said statement in his own hand and provide the felonies.
Well, the finding that he was able to understand his rights, is that enough Or why is that not enough? Is that a wrong? Is that the standard, or what is missing? I guess what finding is missing, and we can find over what the evidence might mean, or if it's conflicting. But if the trial court found that he understood his rights, what is that not enough?
That's not enough. Whether or not he understood his rights is a separate question from whether or not he was conscious of the meaning of the words of his statement at the time that he wrote the statement. So the voluntariness of his statement is a separate question from whether or not he understood his rights. And there, like I said, there was no finding about whether or not he understood the meaning of his words. So I was unable to challenge a finding about that. So ultimately, I'm challenging the conclusion that his statement was voluntary.
And you say there's at least a conflict in evidence whether or not he understood the words that he wrote, which was not resolved by the trial court.
I believe that the evidence here is actually not at issue. I believe it's uncontroverted. But I believe that, yeah, the court should have made a finding under the correct test about whether he was conscious of the meaning of his words.
Now, is this a plain error standard?
It is. This is plain error. Although counsel challenged the statement at a suppression hearing, at the time it was admitted, there was no objection. So it's now plain error standard.
And am I correct that during this questioning, your client on more than one occasion declined to take a breathalyzer or an intoxilizer test?
Before he gave the statement, he declined to do I'm sorry, after he gave the statement, he declined to do the breathalyzer. And prior to that, he apparently in some way acknowledged his rights. But at the time that he gave this statement, one of the police officers testified that he was sluggish and sleepy and that he was laying his head down on the interview table.
So let me get this correct. Before he wrote the statement, he acknowledged his rights. He wrote the statement, and then after he wrote the statement, he refused or declined to take a breathalyzer. Is that correct?
Yes. Yes, Your Honor. Some of the test, however, Trooper DeMuth testified that some of his refusals were actually refusal by inability, that he could not perform the tests. And that was the motion to suppress hearing, page 30.
But he specifically declined to take the breathalyzer, did he not?
As far as I understand, he did refuse to take the breathalyzer, but again, we don't have any video of this, and he indicated that some of his refusals were just because he could not do it, not because he declined to.
So the issue is not whether or not he knowingly waived his Miranda rights, because the trial court found that. It's just when he waived it, his statement that he gave was not voluntary because he didn't know what he was doing. He didn't understand what he was doing.
Yes,
That's the argument. I want to make sure I just nail down what the argument is. It has nothing to do with his waiving his Miranda rights. It's just whether or not the statement he gave was voluntary or admissible.
yes.
Okay.
Yes, Your Honor. So how do we know that he was unconscious of the meaning of his words here? At the time that he left the scene of the accident, he had to be helped into the car. He had to be helped into the building because he couldn't walk on his own. Shortly thereafter, he wrote the statement, and like I said, he would lay his head down on the table and appeared sluggish and sleepy. And when his blood was drawn about an hour and a half later, his BAC was at a 0.19, which is twice the legal limit.
Well, is it your contention that at some point after you've had so much to drink that you can't make a confession? Is that your point?
Yes, Your Honor. I believe at a certain point.
What point number along the scale do you say that is?
I don't think there's not a bright line for, a certain BAC means that you're unable to give a voluntary statement, considering that that's just dependent on a lot of factors. It would be dependent on the person and the situation. But under this circumstance, this is a relatively short period of time. The accident scene, he was arrested at about 6:50, 7 o'clock. And he gave his statement around 8 o'clock, and then his blood was drawn about an hour and a half later. and it was 0.19. So not a lot of time elapsed between all of this.
So, Ms. Katz, let me ask you, did the magistrate find that your client was so grossly impaired that he did not understand the charges or the procedures?
No, Your Honor. The magistrate did not make that finding.
All right. Thank you.
Did they, have we ever held, or any case law that at a certain point, that you're at a certain point of intoxication, BAC, that you are so intoxicated you can't make a statement?
No, Your Honor. There's no DAC level that would per se make someone unable to give a voluntary statement. And actually, this court hasn't found a statement to be involuntary yet, but the cases so far have been in stark contrast to this case, where in most of the other cases, there were findings about how the defendant could talk coherently, could walk on their own, could give details about the incident.
Don't we have that here? They made a finding that he understood his rights. Why is that? Why isn't that enough? That he understood, if he understood his Miranda rights, is it a great leap? Why is it a great leap? Let me ask you, why is it a great leap to say that making that finding is not sufficient to say that he understood what he was writing?
Your Honor, the difference between just assenting or nodding along to your Miranda rights being read to you and then actually choosing to give a statement to the police, I would contend are different things, and there are different thresholds. I believe a person who is very intoxicated could very well just nod along and acknowledge their rights and
understand them. That the finding was
understand
you
them.
can understand those, but you think that's different. You could be competent enough to understand your rights, but not competent or with it enough to know what you're saying. You think there's a,
and I believe that was the situation in this case. Yes.
that is the one finding that we have to overcome. It seems like that we have to make that leap, and I'll let the state argue that. Go ahead.
I believe that if you look, some of the evidence about whether or not this statement was voluntary is just the statement itself. It's very hard to read, and not just because of the handwriting. It doesn't make a lot of sense. It appears to say something like, "I was the driving of the car. Tonight's fully responsible of all acting that happened tonight. I am Tony Gray for all acting that happened tonight." I would contend that that is not a coherent statement. And I believe that that is very good evidence right there that he wasn't conscious of the meaning of what he was saying.
But somebody that writes like that would understand their Miranda rights, or would you even? I mean, because
I can't say, you know, there was no video of him being read his rights, and I can't say whether or not he truly understood his rights. The officer contends that he did, but I believe that this statement evidences he did not know what he was saying at the time that he wrote the statement. And with regard to prejudice on this issue, the state argued that the fact that his involuntary statement failed to meet the required prejudice standard he could not meet the prejudice standard because there was sufficient evidence by which the jury could have found him guilty anyway. That's not the case. And this court's recent decision in State versus Lynch, written by you, Judge Dillon, stated that the fact that there's sufficient evidence to convict a defendant doesn't mean that admission of an inadmissible confession is not prejudicial enough to require a new trial. And this is because, as noted in Arizona versus Fulminante, a confession is like no other evidence. It's probably the most probative and damaging evidence that can be admitted against a defendant. Here,
in that case, it was a prejudicial standard because it was properly objected to. This is plain error. So, I mean, I'd like to hear what is the state's strongest argument that there was evidence that that your client was driving, and why do you think that's I mean, and why is that not good?
Your Honor, I believe the strongest evidence the state had that he was not the driver is this statement, and that is why it rises to the level of.
Besides that, if they say it wasn't prejudicial because they think there was other evidence, what other evidence are they saying shows that your client was driving?
I believe the only other evidence that he was the driver is that he was on the accident scene when he was discovered at the accident scene. There was no eyewitness testimony. There was no physical evidence. He was actually seen on the passenger side of the car. He told 2 witnesses, the cop and a witness on the scene, that he was not the driver. And he, at the time, he stayed on the scene, whereas the other man that was in the car left the scene.
So that's why it would be plain error, because this is the only real evidence that he was the driver, was his confession. So
Yes,
that's why you say it rises to plain error. Okay, I got you.
I believe so.
You talked about that he was on the passenger side of the car. In the evidence that the car was smashed up so bad that one could not get out on the driver's side of the car?
The evidence does suggest that the car was pushed up against a guardrail, and so perhaps he had to get out the other side of the car. But I think it's important that he stayed on the scene and the other man left the scene. I think that speaks a lot to the fact that he may not have been driving this car.
So, Ms. Katz, let me ask you: was there any evidence about who had the keys to the car?
No, there was not any evidence about who had the keys to the car. There was no fingerprints taken in the car. There was no evidence about whether it was his car or the other man's car, or who had insurance on the car, or anything of that nature.
Okay, thank you.
If there's no further questions on this issue, I'd like to turn to the jury coercion issue. The jury here reached a deadlock and told the court the reason for the holdout juror's vote, that he or she would not vote for conviction without an eyewitness account of Mr. Gray being the driver. The court's response to this note, to read the direct versus circumstantial evidence instruction, was reversible error.
This is an abuse of discretion standard, is that correct?
I'm sorry, can you repeat that?
Is this an abuse of discretion standard that we're reviewing it under?
Your Honor, I would argue that this is a harmless error standard, because Mr. Gray has a constitutional right to have a unanimous jury verdict. So I believe that the state has the burden to show that this was harmless error beyond a reasonable doubt.
Is there any case that's ever said that?
I would say in my brief, I cited for that would be State versus Lee on page 19 of my brief.
And can you refresh me of the facts of State versus Lee?
Your Honor, I would have to get back to you on that. But I believe that this is harmless error standard because under the North Carolina Constitution, a defendant has the right to a unanimous jury verdict. Here, I believe that the court cannot say that this was harmless error. When a jury experiences...
So if the judge gives us an instruction and you're saying for the purpose of trying to coerce a juror, that's a constitutional violation that deserves harmless beyond a reasonable doubt. I'm just trying to understand that.
Yes,
okay.
Your Honor. When a jury experiences difficulty in reaching a unanimous verdict, the court may ask them to deliberate further in an attempt to reach agreement, so long as the court doesn't express an opinion as to the guilt or innocence of the defendant, and as long as the court does not imply that any juror should surrender his own free will or judgment. Here, the court did both. First, the court expressed an opinion about Mr. Gray's guilt. Here, the jury did not ask a question or for further instruction. They were simply telling the court that they were deadlocked and why they were deadlocked. The court's choice to instruct on direct versus circumstantial evidence was tailored to address the holdout juror's concern, and it told that juror that his vote was incorrect. This instruction was more than a catalyst for more discussion. Pattern Instruction 104.05, read to the jury, specifically uses eyewitness testimony as an example of direct evidence. The plain takeaway from this instruction to this juror was that it was immaterial that there was no eyewitness testimony, and therefore that this juror should convict. This is not acceptable. Judges are required to ensure that they do not express an opinion to the jury. In fact, there's a pattern instruction read to the jury at every trial to this effect because it's so important. And the judge here failed to guard against expressing an opinion. The judge could have also reminded the jurors that they don't have to surrender their own free will or judgment by reading the Allen charge. The Allen charge was requested by both parties here. Codified in 15A 1235, the rules about the Allen charge are specifically tailored to avoid jury coercion. And the court here could have easily given this instruction and there would have been no problem. The court also could have simply told the jury to remember the evidence and continue their deliberations, and there would have been no problem. But the fact here that the judge specifically addressed the one holdout juror by giving them an instruction that was tailored to tell them, you don't need to worry about the thing that you're worried about, that was reversible error.
Well, excuse me a second. I mean, you're not suggesting that the trial judge did anything other than read the instruction with regard to direct and circumstantial evidence, are you?
Your Honor, I am contending that the judge took the information that the jury gave them, that the holdout juror who would not vote for conviction was not going to do so without eyewitness testimony, and then instructed on direct versus circumstantial evidence. And I believe, although that was a correct statement of the law, it was over objection. The parties had requested the Allen charge, and I believe that under these specific circumstances, it had the effect of coercing a verdict. I'm not contending that, sorry.
Go ahead, Ruben, sorry.
So what else did the trial judge do other than specifically read the instruction with regard to direct and circumstantial evidence? Did he make any additional statements? Did he direct his remarks to, I mean, he didn't know who the holdout juror was, so he couldn't have directed his remarks to that person, could he?
No, he did not know who the juror was, but he gave this instruction to the jury, and I think that there could be only one message that you would receive from getting this instruction. As the holdout juror, if I were read this instruction, I would believe that it meant that my vote was wrong and that I needed to change it. And I believe that that is the effect that it had here. I'm not suggesting that the judge necessarily meant to do this, but that is the plain takeaway that I believe it had on the holdout juror in this situation.
What's the standard if the judge implies, you had that standard from Supreme Court, if the judge implies that the juror, I can't remember exactly what in the coercion,
surrender their own convictions, their own free will. I believe here that this implied to the juror that they should surrender their own judgment and convict.
Because there's two ways you could look at it, because I could see that the juror says that there's no direct evidence and all the judges were, you could imply simply that the judge was reminding the juror, who not knowing who it was, that it doesn't have to be direct, it can be circumstantial. I'm not telling you that you got to find it that way, but know that you can consider, I'm just reminding you can consider circumstantial evidence. But I think what you're saying is the judge should have been a little bit more clear, because you're saying that it could have implied either way, that it could have been a coercion thing, and not, because I think it's perfectly appropriate if a juror has got a misunderstanding of the law, just to explain the law. If that juror's concern was there's no direct evidence, the judge was simply reminded you can consider circumstantial evidence. I'm not telling you have to, but you can. But you're saying the judge should have done a little bit more?
Your Honor, I believe that here it's really important that the jury did not ask a question. They were not asking, is eyewitness testimony required? Is direct evidence required? Can you read us another instruction about this? The jury wasn't asking a question. They were telling the court they were deadlocked, and they happened to give the reason for the deadlock.
If it came to the judge's attention that a juror was not understanding the instructions, perhaps, why isn't it within the judge's discretion to at least remind the jurors what the law is? I mean, and I think the statement, I think a reasonable judge might have thought, you're not understanding the instruction because you're hooked on the fact that just no eyewitness testimony.
Your Honor, in that circumstance, if he really felt inclined to give this instruction, there are things that he could have done to guard against the jury taking this as his him expressing an opinion, like stating specifically that he's not expressing an opinion and they should not take this as he's expressing an opinion, or reading the Allen charge in addition to that instruction, which says in the Allen charge, it specifies that they should not surrender their own free will or judgment. I think either of those things would have made a big difference here. But the fact that, the note says, this is why this person won't vote for conviction. The judge doesn't say anything else, but gives this instruction and then says, okay, I ask you to consider that. And then they end up convicting him. I believe that shows that this was a coercive instruction.
But it is the correct instruction under the law, and the judge had already given it once. Is that not correct?
I'm sorry, I couldn't hear you.
It is, and it is the correct instruction under the law, and the judge had already given it. And I'm sorry, I'm eating into your rebuttal time.
It's okay. Yes, it is a correct instruction under the law, but I think the context in which it was given made it coercive, Your Honor. So
earlier during the regular, as a part of the full instruction, is that correct?
Yes. Your Honor, if there are no more questions, I'll save the remainder of my time for a rebuttal.
Thank you.
Thanks.
Mr. Evans?
Thank you, Your Honor. If I could have just one moment to make sure I can see the camera with the timer. Thank you. I have that set up now. May it please the court, my name is Jonathan Evans, Assistant Attorney General, and I represent the appellate state of North Carolina in this matter. This appeal seeks review by this appellate court of several areas within the trial court's discretion and decisions. Based on the testimony and evidence presented, and given the arguments before it, the trial court fulfilled its duty to rule on these issues and legal questions. What is now sought is a review of these decisions outside of the environment the trial court experienced during their more than week-long trial. The defendant challenges the denial of the motion to suppress, a decision that the state asked this court to affirm. The defendant challenges the action in re-instructing and clarifying the jury instructions, an action the state asked this court to find was proper. The defendant challenges the calculation of the sentencing level, which the state would contend rises only to the level of a clerical error, and the defendant challenges the admission of evidence regarding his prior convictions, which the state asked this court to find was not an error. The defendant's first argument alleges error by the trial court in denying his motion to suppress statements made by the defendant to law enforcement.
Before we get to that, tell me why, even if it was error, why it wasn't prejudicial error. I want to get that out. What evidence was there that showed that this guy was the driver?
Your Honor,
plain error standard, but there's got to be something.
Yes, Your Honor. I believe there was sufficient evidence that the defendant could have been convicted otherwise, that he was the driver of this vehicle. The defendant and one other person, Mr. Edward Tillery, were found on the scene. The eyewitness testimony that is present, which did not obviously describe the actual continued witnessing of the individuals, could certify that there was two individuals in the car, that they were occupying the front seat, and that they were the only individuals seen in the vehicle shortly after the time of the second collision. The evidence would tend to show that Mr. Tillery retrieved something from the glove compartment before leaving the scene. This would demonstrate the use and the possession of that side of the vehicle, the passenger side. The state would point to the evidence that there was prior access and use of the vehicle in this case, that being that the evidence showed that there was a prior DWI charge against the defendant where he was found in possession of that same Infiniti when he was passed out behind the wheel in a different area, but in that same area of the county, I believe. This is not the defendant's vehicle, nor was it Mr. Tillery or Mr. Moore's vehicle. This was actually a separate third party who was discussed at length during trial. The defendant knew that person, and again, this being a vehicle that is not any of the three people potentially there, certainly not Mr. Tillery.
You're saying that if there was if I was charged with a crime and the evidence was that I was driving the car, and the only evidence the state put on was I was known to have driven the car sometime in the past, and the other person retrieved something from the glove compartment, that would survive a motion to dismiss.
I would not contend that that by itself would be enough to survive.
What else was there besides those two things? So the guy was seen known to drive the car in the past because he had a DWI, and the other person was seen taking something out of the glove compartment. What else was there survive a motion to dismiss absent his, I mean, if I was a driver, if it was me and Judge Aaron would drive around, what would be enough to show that it was me driving the car, that it would at least get to the jury?
Your Honor, I would point again to the wristband that was on his wrist was found. This signified again that he had consumed alcohol. Impairment wasn't an issue in this case, but it was the same establishment as before when he was found in possession of the Infiniti. The damage to the driver's side of the vehicle, which was described previously in this argument, signified that the passenger would have had the ability to get out of the vehicle first. The driver would have had to then exit the passenger side. That being a crucial fact with the fact that Mr. Tillery was found to be further away from the passenger side. He was clearly had more time to roam around the scene versus the fact a very short period of time afterwards, the first witness arrived on the scene and noted the defendant to be in immediate proximity to the passenger side of the vehicle.
So did somebody see Mr. Tillery get out of the car first? Nobody saw either one of them get out of the car. So we don't know.
I'm sorry, Your Honor, go ahead.
Was there any evidence of who got out of the car first, I guess is my question.
There was no direct evidence as far as an eyewitness. There was I'm blanking on his name right now, I apologize, but the individual who's driving the truck that saw the actual wreck happen, that second wreck scene about a mile or two later, identified the wreck and then saw two people hunched down in the front seats of the car. That's why he was able to say that there was only two people in the vehicle that he saw. It was then a very short period of time after that one of the individuals that stopped at the initial wreck and then proceeded to follow the silver Infiniti, which had driven off after that wreck, came upon the scene. It was only a minute or two, I believe, based on his testimony later. So the state would contend that very short period of time, this is a fairly serious wreck that caused the car to be disabled on its driver's side to the point where somebody couldn't exit it, that it got wrapped in the median and the fencing there. This would have potentially taken somebody some period of time to exit into another side of the vehicle, and that could certainly be a factor to be used. The state would also...
Excuse me, what's to be gleaned from the evidence that Mr. Tillery left the scene of the accident, but the defendant stayed?
Your Honor, I don't think without any further information as far as why Mr. Tillery left the scene of the collision, that should be something used against him. We do not know. We have a witness who testified to seeing Mr. Tillery retrieve something and then leave the scene. There was evidence that he was intoxicated. There is very little known about Mr. Tillery and the facts surrounding him because he was not available during the trial. But the state would contend that without some further evidence of what exactly was in his possession, should it have been illicit in nature, there was no reason to believe that that was something that would point to him being the driver of the vehicle, subsequent to the defendant who stated and eventually did admit that he was the driver.
So the witness saw him retrieve something out of the glove compartment. Is that right?
That is correct.
Were they both outside the car? Were they both outside the car when Mr. Tillery retrieved something? He reached in and retrieved something. Is that what happened?
I believe that is correct, Your Honor, that the witness saw both people on Mr. Tillery and the defendant on their respective sides of the vehicle. He approached them. He saw Mr. Tillery retrieve something from the glove compartment. That he had a brief conversation where he tried to have him stay on the scene, but then he did subsequently leave the scene while the defendant stayed. He did discuss that brief conversation and trying to get him to remain until somebody else did arrive. The state would also point to Mr. Timothy Moore's testimony, based on not only the testimony he gave, but also what was referred to in the federal probation hearing. The state would contend it was unconvincing. It was in some places self-serving. It was not competent testimony, and that sometimes he referred to himself as driving, yet could not provide crucial facts as far as whether or not he was awake at the time, whether or not he woke up shortly before the wreck, who was doing what beforehand. If anything, he gave a detailed description of the impairment that, or the establishments that they visited that night where there was alcohol served. Besides that, though, we have no information other than the defendant admitting that intoxication is not an issue in this case, as far as when or how the defendant consumed alcohol. The state would indicate, however, that this is a plain error standard. There has to be some showing that it is so fundamental to amount to a miscarriage of justice. So with this other evidence and the showing of no prejudice, this should not be overruled, or this should not be reversed.
Talk about why otherwise this the confession was otherwise okay.
Yes, Your Honor. The trial court did make findings of fact in this matter, as described. Some of them were just recitations of the testimony that was given by the troopers in this case. But some of the facts were found that he was cooperative. He was able to sign in his own hand. The trooper was appropriate and worked with him during that period of time. That he provided him his rights. All those findings, and they were supported by the evidence in the case. The state would find, or the state would contend, that they should be binding on appeal.
Was there any evidence offered that he did not understand? I mean, would you concede there was some evidence that he didn't understand what he was saying when he confessed? Is there any evidence to support that? I'm not asking you to say how the judge ruled, but do you think there was any evidence that might support that?
Outside of the intoxication that has been noted, I don't believe there's any evidence that was provided at trial that would lead somebody, especially the trial court in this matter, to believe that Mr. Gray provided this information involuntarily and did not.
But you would say that the intoxication is some evidence from which a judge could have found that he didn't understand what he was doing.
The intoxication had to be weighed based on the totality of the circumstances by the trial.
Did the judge resolve that conflict by making a finding that he understood? What finding did he make to resolve that conflict? So you've just admitted there's a conflict in the evidence. The judge has to make a finding that he understood what, and I guess the only thing I see is that he understood his rights. Maybe was there any finding that he made to he or she? I don't know what gender the judge was. That the judge resolved that discrepancy in the evidence or that conflict.
Your Honor, the trial court did make a number of findings. As to anything specific, I would have to look at the record. I believe in the amended record on appeal, it contains the written findings of the trial court. He did find the defendant's ability to comprehend as far as the understanding his rights and the ability to write said statement in his own hand. That certainly gives some credence to the fact that nobody else helped him do this. He wrote this statement and he did so by himself. What has been brought up is the handwriting. I would contend that without some further information as far as his education level or anything else, handwriting is something that we as lawyers certainly battle with, as well as other individuals, doctors and high education or high functioning individuals. Handwriting by itself is not indicative of anything, as well as the fact that the trooper indicated that he was handcuffed in front of him, so he had to write this statement while he was in handcuffs. While he was
Didn't the judge also say that because the defendant was not unconscious, he understood what was going on?
He did use the standard of was not unconscious and was not subject to any fits of mania. The state would indicate again that the standard allowed for that there is case law indicating that using the incorrect standard does not by itself render that finding to be invalid. The case being State v. Austin said that simply because an insufficient or superfluous reason is assigned, as well as the fact that whether the ruling of the trial court was correct is not whether the reason is sound or tenable, and whether the ultimate ruling is supported by evidence. So what we would contend is based on the fact that the trial court made findings, and based on the fact that the findings support the conclusions of law that were made as well, the fact that he used arguably a harder standard as far as that he was not unconscious and that he was not unconscious in the meeting or not subject to fits of mania would have resulted in this still being a valid standard. There's also plenty of evidence as far as voluntariness, as far as intoxication goes. EMS was on the scene. They evaluated and ultimately released the defendant back to the trooper, a fact we would indicate subjects that while what has been contended as a very high level of impairment or severe impairment was not so much that they intervened medically at that time. It is admitted that he was provided both his implied consent breath rights and his Miranda rights, and he acknowledged both and responded to both in some way, whether orally or nodding or something to that effect. The statement that was written contained information knowing that driving the vehicle equated to taking full responsibility. Not only does this show an understanding of his rights, but it was the defendant saying the defendant was driving the car that night, I take responsibility. This is also a statement that it was in stark departure from what he had been saying prior, that it was contended that all he said throughout the entire time before this was I wasn't driving the vehicle. he wasn't continuing to incoherently say something over and over again. He clearly made a decision with the trooper only asking him, tell us what happened. He did not know, again, the trooper did not tell him what the date was, yet after writing the statement, he was able to sign and date that appropriately. The alcohol concentration, as we noted in our brief, does not have enough supporting evidence. In fact, there's contradictory evidence trying to indicate as far as some sort of a retrograde extrapolation or something to that extent. There was not enough factors presented. Shortly after the statements were made, again, the magistrate provided him his implied consent notice form. The defendant filled that out appropriately, signed and dated it again. And then the magistrate, who could have made a finding that he was too intoxicated to understand his rights, did not do so. He did not use that mechanism. He continued to fulfill that process at that time. After providing the information and writing the form, he refused the breathalyzer. He refused the ability to do any other standard field sobriety testing when he was presented to the custody of the local police officer who eventually got the blood warrant. He refused to provide any additional information after that. So that clearly shows some different decision at that time in order to make that writing and provide that statement. At this time, the state would ask that the court affirm the ruling of the trial court there. Moving on to the next argument is that the trial court was required that a new trial will be required based on the trial court's re-instruction after receiving a note from the jury. The state, again, argues the abuse of discretion in this matter. The defendant has indicated that this would potentially violate Article 1, Section 24, and argues harmless error. However, what is sought here is a statutory right, that being under 15.8.1234, which is argued by the defendant. But certainly the instructions and the requirements for instructions of a jury are a statutory right. There is case law, including State v. Prevet, that we would point to that indicates that a trial court is in the best position to determine further instruction will aid or confuse a jury in its deliberations, and the abuse of discretion is noted in that case. The abuse of discretion would be only occurs where it's manifestly unsupported by the reason or so arbitrary. This was a reasoned decision that was noted by the court. As far as going into whether or not this was coercive, which is what the defendant has argued, you have to look at the circumstances under which the instructions were given, as well as whether or not they had a probable impact on the jury. Looking at the State v. Fernandez case, it's determining whether or not there is a difference between the coercion or whether this is merely serving as a catalyst for further deliberations. The State v. Bowman case indicated it is not an abuse of discretion to respond to a jury's precise question or to re-instruct the jury on only that portion which is concerned. As far as whether or not this led to undue, I'm sorry, Your Honor.
The jury didn't actually ask a question here, did they? Judge Cole just took it upon himself to give the instruction he felt was appropriate based upon what the jury note was. They did not actually ask a question. Is that correct?
Well, there was not a question mark at the end of the third note. I will admit that. However, the first note that was provided indicated the count as it was. That was the day prior before they broke for the day. Indicated the count and then said, what do we do from here? The court and the counsel both agreed to allow them to come back the next day if that was their wish, which it was. And then that next day they provided the note about a half hour later saying still 11 to 1, that same count, and then indicating why the eyewitness, the juror that was the holdout, did not want to convict based on the eyewitness testimony. I believe reading these two notes together would indicate to the trial court in a reasoned manner that the same count was present both times. There wasn't a large break. There wasn't a large period of deliberation between the two that it would indicate that they were deadlocked. Certainly, this was only about 2 to 2.5 hours of deliberating over a 9-count charge or 9-charge verdict sheet. But the fact that they had indicated why that person was still voting no would certainly lead the court to understanding they had previously asked for guidance as far as what do we do now. And now they were providing a reason for why they were still deliberating. I think the court was fair in reading that this was something that they were potentially asking for. Now, it may have been just an instruction as far as this is why we were still deliberating, but I think the court was fair and did not abuse its discretion in reading that note. The Defendant had already previously admitted that the only point of contention was who the identity of the driver was. The jury had now told them twice what the count was and now provided a reason for that. It was directly related to the instruction of the court, which they had already provided. The trial court can provide a statement clarifying a legal distinction without expressing an opinion. The reason why the state cites to the State v. Crane case shows that there was a reasoned decision by the trial court, as well as in this case. There was a factual determination of whether or not there was an oral right or an oral statement or a written statement. And the jury was not asking about the statement, but was asking about the form of that statement. Trial court in their instruction indicated there's no legal distinction from a legal standpoint, there's no distinction whether this was in writing or orally given if you believe that the statement beyond a reasonable doubt was made.
Well, why isn't this a question for, why wasn't this an Allen charge situation as opposed to this?
I'm sorry, Honor, I couldn't hear your question.
Why wasn't this an Allen charge situation as opposed to the Judge Cole just picking out what he thought he'd give them?
Well, Your Honor, the Allen charge was requested by both counsels. However, again, this was not an additional instruction, so there was no objection that could be re-argued. But ultimately, the court indicated that they were giving this instruction because this directly did involve a determination, a legal determination that would have to be an instruction to the jury. This was an instruction that was previously given, along with the weight of the evidence, along with the fact that they would have to determine who the driver of the vehicle was, as well as the elements of each charge, including if you do not so find or have any reasonable doubts, it will be your duty to return a verdict of not guilty. As was pointed out, there was no previous question on that grounds, but there was also no probable impact on the jury at that point, as far as whether or not this instruction did do something.
The state can't really argue, can they, that there was no effect on the jury. It was 11-1. The judge gives this instruction and they come back with a unanimous verdict. The state really can't, with a straight face, argue that instruction had no effect on the jury, can you?
Your Honor, the state would argue that not only was there no probable impact on the jury, but at the time of the deliberation, it indicated that there was no impact. The defendant in their brief indicated that the State v. Brown unpublished case listed some of the factors that the court could use in determining, based on the totality of the circumstances, whether or not this was coercive. Some of the factors include the complexity of the evidence and the number of charges involved.
I'm not asking about the effect. I'm not asking about the coerciveness. I'm asking about, you said it didn't have any effect on the jury's verdict. And that's what I'm honing in on. Clearly it had an effect on the jury's verdict. I'm not saying that it was coercive. I'm just saying clearly it had an effect on the jury's verdict.
Well, the state would clarify that the instruction was sought to have an effect on the jury. The whole point of making the instruction by the trial court was to clarify whether that they were supposed to follow the law that was instructed to them, that being that direct and circumstantial evidence are to be weighed equally. That the holding out or trying to determine whether or not there was direct evidence would not be relevant if that was the issue that they were encountering. He was to consider circumstantial evidence as well. If that did not meet that standard, they were not required to, based on the other jury instructions, to find him guilty. They would, if they did not find an element of the charge, have the duty to find him not guilty. I think that the amount of time, which is also a factor in the coercion test, but looking at the amount of time that was spent, the jury deliberated for less than 2 hours before they indicated in that first note that they were 11-1. They then resumed deliberations in the morning. A half hour later, they came out with a new note indicating the same vote. After they were reinstructed, they deliberated for almost an hour and a half before reaching the same verdict. The state would indicate that that is a considerable amount of time, considering that they had, in some relative aspects, only deliberated for a brief period of time before that. And given the fact that there was only one real issue in this case, the identity of the driver, that was something that would not theoretically take a long period of time if that was the only hangup. If as the defendant has indicated, this was an egregious instruction by the trial court in abusing its discretion and violating his rights, This wasn't something where the trial court, in its tone and in its language, told them, you are incorrect. This was the trial court giving them a reinstruction and them, again, considering it, whether or not the count changed. But ultimately, all we know is that the verdict eventually came that they found that he was the driver beyond reasonable doubt. So to say that there was some immediate impact, which is not the standard, but to say that there was some impact that did eventually lead to the verdict, we can't know that based on the fact that he was eventually convicted. That would be to say that it was the same count throughout, that it did not change while they were in there. Again, the Allen charge did not need to be given. The defendant actually in their brief cited to State v. Brown, which in that case, one of the matters that was present was the Allen charge. The defense attorney in that matter actually provided the judge a different Allen charge, finding that the first one was too coercive. There have been matters that have indicated that Allen charges can be too coercive. In this matter, there was no. The only objection that was made in the trial was that the Allen charge was not given, and that the judge was seeking to find or to give the direct versus circumstantial evidence charge. There was nothing objected to, in my belief, that said that they found that reinstruction to be overly coercive. I know that the defense attorney indicated that he indicated that the juror indicated what his viewpoint or what his opinion was. However, there was certainly the ability for the judge, given the prior instructions that he would give, to believe that he needed to give this reinstruction to clarify and to have them remember that they are to give both weight to direct evidence and circumstantial evidence, especially given the fact that there was little to no direct evidence in this case. There was certainly no contended eyewitness as far as him getting out of the vehicle or him being the person that was in the driver's seat evidence. The state did not contend that. The defendant argued as such in their argument that in the previous argument that there was not enough to say that otherwise he would have been the person to be found as the driver. However, as our Supreme Court has stated in State v. Dawson, where a careful trial judge, as here, repeats a part of a jury instruction for the express purpose of delineating the law and clarifying its application to factual situations requiring a verdict, his diligence will be commended rather than condemned. So the state would argue that the court, based on all the factors that were present and based on what the state has argued in their brief, made a reasoned decision in this case, that absent an abuse of discretion, that reason should not be overturned. This case should not result in a new trial. The state would briefly touch on the third issue on the calculation of the sentencing law. The state has, in the reply brief by the defendant, has contended that it is a clerical error in fixing the argument as was outlined in both defendant and state's brief. The state would concede that based on the record on appeal, the statutory requirements for notice were not met. This would be remanded solely for the purpose of clerical error because this does not change the sentencing level. Finally, the state would touch on the last argument of error, because this is a matter that is controlled by the Waycaster case, which is still pending before the Supreme Court, but has not been ruled on by the Supreme Court even after arguments. The state would just briefly distinguish it in saying that this matter did involve a live witness, the custodian of the records, one of the clerks, coming in and testifying as to what ACES was, how it's used, that some of the once a judgment or once a paper judgment or something, a record of the court has been accepted and fulfilled, they will put that information into ACES. The witness testified to being a record keeper, how it is entered into ACES, and that the documents are certified copies of the maintained record of prior convictions, which is ACES. There was also testimony in this case that they were unable to get that record from AOC, who they listed as the controlling individual of the microfilm of purged records. I will indicate that in the dissent of Waycaster, there was articulated that there was no evidence in that trial of a reasonably diligent search that was given that would lead to an argument as far as the best evidence rule. In this matter, there was some information given as far as a request being made and a request not being fulfilled that would lead to the original argument being arguably unavailable. The state would not argue at this time that the records by themselves are admissible, yet would argue that the state has laid the proper foundation in this matter for the record, which was presented to be considered what it is, and B, a record or records of prior conviction, which shall be admissible under 14-7.4, the controlling statute with respect to habitual felon prior conviction proof. If there are no further questions for the reasons stated in my brief, I would ask this court to affirm the defendant's convictions and find that there was no error.
Thank you, Mr. Evans. Ms. Katz, I'll let you have 5 minutes because I know we ate into your time a little bit. So,
thank you, Your Honor. First, I'd like to just address a couple of the facts noted by Mr. Evans in the voluntariness issue. With regard to the glove box, I would believe that this fact does not rise above speculation or conjecture that he was the driver. I don't know about you, but I don't keep possessions in someone else's glove box. So I think it speaks to the fact that Mr. Tillery, that could have been his car, or he could have been the driver of the car, and that's why his possessions were in the glove box. Overall, we don't know what that really says. So I don't believe that that's a fact that we can look to say, yes, this is sufficient evidence that Mr. Gray was the driver here. Along those lines, also, where they were standing, I think ultimately it's speculation as to who got out of the car first and where they were standing. I don't believe that the fact that he was standing next to the passenger seat, if you believe that he would have had to get out second, is sufficient evidence to prove that he was the driver of the car. I think, again, that doesn't rise above the level of speculation and conjecture here. Also, I believe that Timothy Moore's testimony, if you believe it's not credible, is not evidence in and of itself that Mr. Gray was the driver of the car. Again, this is not sufficient evidence to show that he was the driver of the car. So I believe that had this statement not been admitted into evidence, the evidence here would not have been sufficient to show that Mr. Gray was the driver of the car.
What about the evidence which you neglected to mention before, and you've not mentioned it now, that there's a previous record of your client driving this car and having been arrested for driving this car? Doesn't that cut against your client?
I believe that that fact alone does not rise to the level of substantial evidence.
I'm not saying alone, but that fact does cut against your client in this case, does it not?
Sure, I believe that that is a weak fact that supports that he could have been the driver of the car, but I do not believe that that's substantial evidence by which a reasonable person could have said that he was the driver of this car on this occasion. I believe that this rises to the level of plain error, fundamental error, because whether or not he was the driver of this car determined whether he was guilty of 10 charges that carried with it 43 years of imprisonment. So I believe that here, this was a very close case, and this statement was really the only evidence that he was the driver. And I believe if that does not rise to the level of plain error, what does? With regard to the coercion issue, I'd like to emphasize again that the jury didn't ask a question. And when they did previously ask, what do we do now? That wasn't asking for more instruction. That was asking, we are deadlocked. What do we do now? So I do not believe that that is something that indicates that there was not coercion here. I still contend that this is harmless error, but even under an abuse of discretion standard, I believe that this was prejudicial. I believe this was an abuse of discretion. Giving this charge and addressing the holdout juror by implication was a coercive choice by this judge. It was not manifestly supported by reason. The judge here could have done many other things, like I mentioned, could have given the Allen charge, could have simply asked them to recall the evidence, or could have asked clarifying questions. The judge here could have said, are you asking whether, eyewitness testimony is required, or are you asking for more instruction? But the judge did not ask any follow-up questions of the jury and instead just gave this instruction. And I believe...
Have you cited any case in your brief where situation like this is found to be coercive. I've looked at Lee. One of the benefits of having the books behind me is I looked at Lee, and in Lee you correctly cite the standard, but they find that what was done there was not coercive.
I believe that this, even though this could be viewed as an instructional error, but I believe under these circumstances, it is an issue of jury coercion, and that he has a constitutional right to have a verdict that is not influenced by the judge.
But have we ever found that a jury instruction in and of itself is coercive in North Carolina? Can you cite me to those cases where we found that?
I cannot cite you to that off the top of my head, no.
And in fact, you don't cite any in your brief either, do you?
Well, I believe that under either standard, under any standard, I believe that this rises to the level of coercion, and that this was an incorrect response in response to the jury's note here. I believe that there's really only one way that this could have been received by the holdout juror, and that shows by the fact that they then convicted. There's just no telling what would have happened had a different charge been given here, whether this would have ended in a mistrial. You just can't know what would have happened here under these circumstances. And for these reasons, I would ask that this court find that Mr. Gray's motion to suppress was improperly denied, and that the court instructed the jury in such a way as to coerce a jury verdict, and therefore that he's entitled to a new trial.
Thank you so much for your arguments. We will take this under advisement. And Mr. Horn, are you there to adjourn us?
Yes. Are you ready for me to close court?
Yeah, go ahead and close court.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you all.
Thank you.
Thank you.
Thank you, Your Honors, and thank you, counsel.
Thank you.
Great job. Thank you for accommodating us.